Hello and welcome everyone to the Drishti IAS English YouTube channel. I'm Pragya with you today. So in our today's episode of Target UPSC Prelims MCQs Practice Series, we'll be discussing the MCQs from the subject of Polity Set 8. So let us begin our discussion today. So the very first question of our today's discussion is, consider the following statements. Your statement number 1 is, a notified area committee is an elected body. Your statement number 2 is, a town area committee can only be an elected body. So the keyword here is only. Your statement number 3 is, a cantonment board established by a separate act passed by a state legislature. And your statement number 4 is, a port trust is set up by an act of the parliament. How many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all of the above. And your option D is none of the above. So the correct answer for this question is going to be option A, only 1. So the type of urban local bodies that have been created in India for the administration of urban areas. So the urban local bodies have been created by the 74th Constitutional Amendment Act, which talked about the grassroots level democracy in the urban areas. So if I talk about the notified area committee, it is created by the notification in the government gazette. It is not an elected body. It is established for the administration of two types of area. Firstly, a fast developing town due to industrialization, and secondly, a town not yet developed to fulfill all the conditions to create a municipality but is considered important by the state government. Though its powers are equivalent to those of the municipality, but unlike the municipality, a notified area committee is an entirely nominated body. Municipality is an elected body, right? And what differentiates a notified area committee from a municipality? That it is a nominated body and not an elected body. The state government nominates all members, including the chairman. Thus, a notified area committee is neither an elected body nor a statutory body, and that is why your option number 1 herein is incorrect in nature. And now if I talk about the town area committee, so basically it is established by a separate act passed by the state legislature. So your statement number 2 will also be wrong because it is not an elected body. And wherever you see such negative words only, you can clearly eliminate the answer if you do not know the correct answer. Okay, so this technique helps in the elimination as well. These kind of negative words such as only. So the town area committee was created for the administration of a small town. Small town. It is like a semi-municipal authority and is entrusted with a limited number of civic functions like roads, street lightings and drainage. The act that is created by the state legislature mentions the composition, functions and other matters related to the town area committee. It may be a wholly nominated body, that is by the state legislature, that is by a state government, or a wholly elected body, or a mix of both. And that is why your statement number 2 is also incorrect in nature. Coming to the cantonment board. So it is established for municipal administration for the civilian population in the cantonment areas. It is created under the provisions of the Cantonments Act of 2006. Cantonments Act of 2006. This means that it is not established by a separate act passed by a state legislature. And that is why your statement number 3 is incorrect in nature. A cantonment board functions under the administrative control of the Ministry of Defense. Ministry of Defense. The members of a cantonment board are partly elected and partly nominated. The elected members hold office for a term of 5 years, while the nominated members continue as long as they hold office in that station. The military officer who is the commanding the station is the ex officio president of the board, and he presides over the meetings. The executive officer of the cantonment board is appointed by the President of India. Now coming to the fourth statement, that is a port trust. So basically the port trusts are established in port areas like Kolkata, Chennai, Mumbai, etc. The objective to create port trust is to manage and protect the ports and to provide civic amenities. A port trust is set up by an act of the parliament, and that is why your statement number 4 only is correct here. Its members include both elected and nominated members, and its civic functions are almost similar to those of a municipalities. And that is why the correct answer for this question is option A, only one. Moving forward to the next question of our today's discussion. So the question is, which of one of the following does not describe a civil society suitably? Option A, it interconnects individuals and families. Option B, it comprises of voluntary associations. Option C, it does not assert autonomy from the state. Option D, it is modern rather than prescriptive and traditional. So it is asking which is not describing the civil society suitably. So the correct answer for this question is going to be option A. That is, it interconnects individuals and families is not correct in nature. So if I talk about the civil society, it refers to a wide array of organizations such as community group, non-governmental organizations also known as NGOs, labor unions, indigenous groups, charitable organization, faith-based organizations, professional associations and foundations. Civil society is the arena outside family, government and market where people voluntarily associate to advance common interest based on civility. So basically, a civil society organization and governments cooperate in numerous ways, from joint policy development to funding agreements. They work to formulate enabling laws and policies and create mechanisms that foster cooperation. Civil society does not claim independence from the state. And civil society is a set of associations which is neither state nor family. So it is neither state and nor family, but they play a very positive and active role in social, economic and cultural activities. Civil societies are modern rather than ascriptive and traditional. They promote democratic regimes, and that is why your option A is the correct answer for this question. Moving forward to the next question of our today's discussion. So the question is, with reference to the functions of Election Commission of India, and which article of the Indian Constitution talks about the Election Commission of India? It is Article 324 of the Indian Constitution. Consider the following statements. Your statement number 1 is, it can postpone or cancel the election in the entire country or a specific state or constituency on the grounds that the atmosphere is vitiated. Option 2, it can order a re-poll in a specific constituency. Option 3 is the administrative officers of the state and central governments are assigned election related duty, and in this respect the election commission cannot transfer the officers or stop their transfers during the election process. How many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all of the 3. And your option D is none of the above. So the correct answer for this question is going to be option B. Only 2 statements that are given herein are correct in nature. So basically, the powers and functions of the Election Commission of India can be classified into different categories. That is administrative, then quasi-judicial, and then it can also be advisory in nature. During this process, the Election Commission can make decisions to ensure a free and a fair poll, because this is what is mentioned under Article 324, that Election Commission of India is entrusted with the duty of conducting free and fair elections in India. So for this purpose, it can postpone or cancel the election in the entire country or a specific state or constituency on the grounds that the atmosphere is vitiated and therefore a free and fair election may not be possible. The Commission also implements a model code of conduct for parties and candidates, and that is why your statement number 1 that is given here is correct in nature. It can also order a re-poll in a specific constituency. It can also order a recount of votes when it feels that the counting process has not been fully fair and just, and that is why your statement number 2 here is also correct in nature. During the election process, the administrative officers of the central and the state governments are assigned election related duty, and in this respect, the Election Commission has full control over them. The Election Commission of India can transfer the officers or stop their transfers even, and that is why your statement number 3 herein is incorrect in nature. So the correct answer for this question is going to be option B, only 2 statements. Moving forward to the next question of our today's discussion. So the question is, the Chief Election Commissioner can be removed before the expiry of the term by option A, Prime Minister, option B, the Chief Justice of India, option C, the Minister of Law and Justice, and option D is the President of India. So as you all are guessing right, the correct answer for this question is going to be option D, the President of India. So basically, Article 324 clause 5 of the Indian Constitution clearly states that the Chief Election Commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court, and his conditions of service shall not be varied to his disadvantage after the appointment. The CEC can be removed before the expiry of the term by the President if both the Houses of Parliament make such a recommendation with a special majority. This is done to ensure that a ruling party cannot remove a CEC who refuses to favor it in election, and this is also done to ensure that yes, Election Commission should be a transparent body. It should be an independent body. Further, any election commissioner or a regional commissioner shall not be removed from office except on the recommendation of the Chief Election Commissioner, and that is why your option D is the correct answer for this question. Moving to the next question of our today's discussion. So the question is with reference to the State Election Commission consider the following statements. Your statement number 1 is the state election commissions are constituted under the 73rd and the 74th amendments in the Constitution of India. Your statement number 2 is the state election commissioners are appointed by the chief election commissioner. Your statement number 3 is the conditions of service and tenure of the office of state election commissioners are decided by the governor. Your statement number 4 is the state legislatures are not authorized to make provisions with respect to the matters relating to the elections to the panchayats. Which of the statement given above are incorrect in nature, are not correct in nature? So time and again I remind you to read the question very carefully, because there are chances that you will read it as correct in nature and you will mark the options accordingly. But please give some time to read the question carefully to avoid any kind of silly mistakes in your examination. So option A 1 and 3 only, option B 2 and 4 only, option C 3 and 4 only, and option D is 1, 2, 3 and 4. So the correct answer for this question is going to be option B, 2 and 4 only. So basically the Constitution of India provides that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as unit of local self-government. The state election commissions constituted under the 74th and 73rd amendments in the Constitution, which came into effect on 24th April 1993. They are vested with the powers to conduct elections of corporations, municipalities, Zilla Parishads, district panchayats, panchayat samitis, gram panchayats and other local bodies. And that is why your statement number 1 herein is correct in nature. The superintendent's direction and control of the preparation of electoral rolls and conduct of all elections to the panchayats is vested in the State Election Commission. It consists of a state election commissioner that is appointed by the governor, and that is why your statement number 2 herein is incorrect in nature. They are not appointed by the chief election commissioner, rather they are appointed by the governor for the state. The conditions of service and tenure of the state election commissioner shall be determined by the governor. He shall not be removed from office except in the manner and on the grounds prescribed for the removal of a judge of the state high court. His conditions of service shall not be varied to his disadvantage after his appointment. And that is why your statement number 3 here is correct in nature. Further, the state legislature may make provision with respect to all matters relating to elections to the panchayats, and that is why your statement number 4 here is also incorrect in nature. The state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Institutions of self-government. Because this was the purpose behind the enactment of the 73rd and 74th Constitutional Amendment Act, that we wanted to bring democracy on a grassroots level. So that is why the state legislature may endow the panchayats with such powers as is helpful to them to function as a institution of self-government. And that is why the correct answer for this question is option B, 2 and 4 only. Moving forward to the next question of our today's discussion. So the question is, consider the following statements regarding the Union Public Service Commission or the UPSC. Your statement number 1 is, a person who holds office as a member of Public Service Commission shall be ineligible for reappointment to that office. Your statement number 2 is, the Constitution empowers the Parliament to determine the strength and composition of the Commission. So, which of the statements given above are correct in nature? Option A, 1 only. Option B, 2 only. Option C is both 1 and 2. And option D is neither 1 nor 2. So, the correct answer for this question is going to be option A, 1 only. So, if I talk about the Union Public Service Commission or the UPSC, it is an autonomous constitutional body and as aspirants definitely we can relate to this commission more than we can relate to anything else. We know how strict the UPSC is. The constitution has provided various safeguards to maintain the independence of the UPSC from any kind of executive interference. Article 316 clause 3. A person who holds office as a member of a public service commission shall, on the expiry of the term, be ineligible for the reappointment to that office. And that is why your statement number 1 herein is correct in nature. The chairman of UPSC, on expiry of his tenure, is not eligible for further employment either under the Government of India or any state government. A member other than the chairman of UPSC on expiry of his tenure is only eligible for appointment as the chairman of UPSC or any other state public service commission, but not for any other employment either under the Government of India or any of the state governments. The Constitution has not determined the strength of the commission specifically and has left it to the discretion of the president, who decides its composition from time to time, and that is why your statement number 2 here is incorrect in nature. Consequently, in pursuance of Article 316 clause 1 of the Indian Constitution, the President appoints 9 to 11 members to the Commission, including the chairman, and Article 318 of the Indian Constitution empowers him to determine their conditions of service. If the office of the chairperson falls vacant or he is unable to perform his functions due to absence or reasons otherwise, the president can appoint any member of the UPSC as an acting chairman. And that is why the correct answer for this question is option A, 1 only. Moving forward to the next question of our today's discussion. So, which of the following forms the part of the functions of the National Commission for Scheduled Tribes? Your option A is taking measures for conferring ownership rights in respect of minor forest produce to the STs. Option option 2 is to inquire into specific complaints with respect to the deprivation of rights and safeguards of the STs. Option 3, to take measures to ensure full implementations of the PESA Act of 1996. How many of the statements given above are correct? Your option A is only 1, your option B is only 2, your option C is all 3, and your option D is none of the above. So the correct answer for this question is going to be option C. All of these statements are correct in nature. And the National Commission for Scheduled Tribe has been constituted by Article 338 of the Indian Constitution. And let me know in the comment box below by which constitutional amendment Article 338A was added in our Indian Constitution. So basically, the Constitution under Article 338 Clause A, Subclause 5. Article 338 Clause A, Subclause 5 mandates the National Commission for Scheduled Tribes to perform the following functions. Firstly, to investigate and monitor all matters relating to the safeguards provided to the scheduled tribes under the constitution or under any law for the time being in force or under any government, and to evaluate the working of such safeguards. Secondly, to inquire into specific complaints with respect to the deprivation of rights and the safeguards of the scheduled tribe community, and that is why your statement number 2 here is correct in nature. To participate and advise on the planning process of the scheduled tribes socio-economic development and to evaluate their progress under the union or any state. To present reports to the president annually and at such other times as the commission may deem necessary upon the working of those safeguards. To recommend measures required to be taken by the union or any state for effective implementation of programs and schemes relating to the welfare and social economic development of the scheduled tribes. To discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled tribes as the president may by rule specify, subject to the provisions of any law made by the parliament. Now let us talk about the additional functions that has been entrusted upon the National Commission of Scheduled Tribes by the Ministry of Tribal Affairs. Firstly, to confer ownership rights in the respect of minor forest produce to the STs living in the forest areas, and that is why your statement number 1 here is correct in nature. To safeguard the rights of the tribal communities over mineral resources, water resources, etc. as laid down by the law. To plug loopholes and to work for more viable livelihood strategies. To improve the efficacy of relief and rehabilitation measures for tribal groups displaced by the development projects. To prevent alienation of tribal people from the land and to effectively rehabilitate such people in whose case alienation has already taken place. To elicit maximum cooperation and involvement of tribal communities in protecting forests and undertaking social afforestation. Social afforestation. To ensure full implementations of the provisions of Panchayats extension to the Scheduled Areas Act of 1996, also known as the PESA Act, and that is why your statement number 3 here also is correct in nature, and that is why your statement number option number C is the correct answer for this question. Moving to the next question of our today's discussion. So the question is, with reference to the National Commission for Scheduled Castes or the NCSC, consider the following statements. Option 1 is Article 338 Clause A of the Indian Constitution deals with the National Commissions for SC. Your statement number 2 is, apart from the SCs, the Commission is also required to discharge similar functions with regard to the other backward classes. So which of the following statements given above are incorrect in nature? Option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So it is asking that which of the statements given above is incorrect in nature or not correct in nature. So the correct answer for this question is going to be option C. Both 1 and 2 are incorrect in nature. And I'll tell you why. Article 338, which was inserted by the 89th Constitutional Amendment Act, talks about the National Commission for Scheduled Tribes. It does not talk about the National Commission for Scheduled Caste, and that is why your statement number 1 is incorrect in nature. National Commission for Scheduled Caste is mentioned under Article 338 of our Indian Constitution. Till 2018, the National Commission for SCs was also required to discharge similar functions regarding the other backward classes. But then we enacted the 102nd Constitutional Amendment Act, And now we have a separate body known as the NCBC, or the National Commission for Backward Classes, which provides constitutional status to the National Commission for the NCBC, and it is responsible for the welfare of the other backward classes in India. And that is why both of these statements in this question is incorrect in nature. So option C is your correct answer. Now moving forward to the next question of our today's discussion. So the question is, which of the following statements are correct? Firstly, the first statement is, the accounts of the District Council of Tribal Areas mentioned in the 6th schedule of our Indian Constitution may be kept in such form as prescribed by the Comptroller and Auditor General of India. Your statement number 2 is, the Comptroller and Auditor General, that is the CAG, shall cause the accounts of the district and regional councils to be audited. Your option 3 is, or statement 3 is, the report of the Comptroller and Auditor General relating to the accounts of the district council may be submitted to the President to be laid in the Parliament. How many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all of the 3, and option D is none of the statements given herein are correct in nature. So the correct answer for this question is going to be option B. Only 2 statements are correct. So 6th schedule in the Indian Constitution has established the autonomous district councils, or the ADCs, in 4 northeastern states, namely Assam, Meghalaya, Tripura and Mizoram. These ADCs envisage protecting and preserving the tribal culture. So according to the provisions of 6th schedule of the Constitution of India, there shall be constituted for each autonomous district a district fund, and for each autonomous region a regional fund, to which shall be credited all monies received respectively by the district council for that district and the regional council for that region in the course of the administration of such district or region, as the case may be, in accordance with the provisions of the Constitution. The governor may make rules for the management of the district fund, or as the case may be, the regional fund, and for the procedure to be followed in respect of payment of money into the said fund, the withdrawal of monies therefrom, the custody of monies therein, and any other matter connected with or ancillary to the matters aforesaid. The accounts of the district council or the regional council shall be kept in such form as the Comptroller and Auditor General of India may, with the approval of the President, prescribe. And that is why your statement number 1 here is correct in nature. The CAG shall cause the accounts of the district and regional councils to be audited in such a manner as they may deem fit. And that is why your statement number 2 also is correct in nature. The reports of the CAG relating to such accounts shall be submitted to the governor. Shall be submitted to the governor, who shall cause them to be laid before the council, and that is why your statement number 3 is incorrect in nature. So the correct answer for this question is option B, only 2. Now let us discuss question number 10 of our today's session. So the question is, consider the following statement regarding the GST Council. Your statement number 1 is, it is an extra constitutional body for making recommendations to the union and state government on issues related to the goods and services tax. Statement number 2 is, it can establish a mechanism to adjudicate upon the dispute between the center or states or between states among themselves. So, which of these statements given above is are correct in nature? Option A, 1 only. Option B is 2 only. Option C is both 1 and 2, and option D is neither 1 nor 2. So the correct answer for this question is going to be option B, 2 only. So if I talk about the GST Council, it is a constitutional body, and Article 279 Clause A of the Indian Constitution mentions about the GST Council, and it is there for making recommendations to the union and state government on issues related to the goods and services tax. So that is why your option number 1 herein is incorrect, because it states extra constitutional body, but it is not an extra constitutional body, rather it is a constitutional body that has been established under Article 279 Clause A of the Indian Constitution. The GST Council is chaired by the Union Finance Minister. The center has 1/3 voting power and state have 2/3. The decisions are taken by a 3/4 majority. The GST Council can consider increasing the cess or including more products under the cess or a compensation. Levy can be extended beyond 5 years to meet this GST shortfall. The Council can also provide a mechanism to adjudicate upon the dispute with respect to its recommendation or their implementation between center and states or among states themselves, and that is why option 2 herein is correct in nature. Now, this is the practice question for you. So, the question is, which of the following statements with respect to the composition of the State Human Right Commission are correct? Your statement number 1 is, the commission is composed of a chairman and 4 members. Statement number 2, the chairperson and members are appointed by the governor. Statement number 3, a person who has been the Chief Justice or Judge of a High Court is eligible to be the chairperson of the commission. So, how many of the statements given above are correct? Option A, only 1. Option B, only 2. Option C is all 3, and option D is none of the above. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, kindly feel free to drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.